Floyd Zadkovich, International Commercial Lawyers.
I wanted to talk about one of my favorite topics in the maritime law sector, which is asset seizure and security enforcement, gaining security for the claims which you may have, be those claims against cargo interests or claims against vessel owners or claims against parties which don't necessarily fit directly into that paradigm. And I'm well aware that many here will already be quite familiar with the basics of maritime attachment, otherwise known as Rule B attachment, vessel or maritime asset arrest, otherwise known as Rule C arrest, maybe some degree of familiarity with the state law procedures, which can be incorporated into a security plan pursuant to Rule B. It allows for incorporation of state procedures, and that includes as well security for pending arbitration claims, be they arbitration claims pending in the U.S. or claims pending in foreign fora. But my view on securing claims is that since the so-called Jaldhi decision of roughly a decade ago, many have become a little bit complacent or overly pessimistic about the prospects for securing claims. Back in pre-2009, or whatever the exact year was, when the Second Circuit issued its decision in Jaldhi, which prevented, as most of you would know, intermediate wire transfers from being seized as they passed through intermediary banks in New York. Prior to that decision, unfortunate decision that it was extremely easy and simple to secure $500,000, $1 million, $10 million, or in one case that I handled, I think it was $80 million almost overnight. It was easy. It was so simple because the money was flowing through and you could just catch it. In the immediate aftermath of the Jaldhi decision, asset seizure in New York and elsewhere in the US slowed down. It certainly slowed down. But what we have seen over the past several years is there are still good opportunities to secure assets, be they pieces of cargo, cash that may be sitting in a bank account, in some instances, vessels themselves or other types of maritime property, or one can get just plain creative. And that's actually what I wanted to get to as a bottom line here today, is some creative thinking. I think the moral of the story, the lesson of the story, is that everyone should look to be creative when they have a claim against a company that may be set up in some offshore jurisdiction with very murky asset picture, where yes, you can probably obtain an award or a judgment against that company for whatever amount of money may be owed, but the ability to enforce that award or judgment is going to be very challenging because of the nature of the company. So with that said, let's go through some basics on maritime attachment, Rule C arrest, state law procedure very quickly, and then talk about some creativity. Rule B, maritime attachment. 4 simple requirements in play for it. Number 1, that the claimant has a prima facie maritime claim. There's some disparity in determining what exactly a prima facie maritime claim means. Leave that to the lawyers to argue with judges and adversaries about what exactly that means, whether it is a so-called evidentiary standard or a mere pleading standard. Pleading standard is certainly the easier one to satisfy from the perspective of a plaintiff. But you need to have a prima facie maritime claim. I think from the perspective of commercial participants who might not be in-house counsel, it's simple. It's sufficient to view that as being, if you have a claim that relates to the water or relates to a contract that is tied to water, is maritime in nature in some fashion, talk to an attorney about whether or not you have a prima facie maritime claim, because it may be there. Second requirement is that the defendant cannot be found within the federal district. Federal district, for those who don't know, is simply the Southern District of New York, the Eastern District of New York, the District of New Jersey, the Southern District of Texas, so forth and so on. That's the district. It does not, on face level, and I won't get into the details beyond that, on face level, it does not necessarily mean the entire state, unless the district is coterminous with an entire state. For instance, the District of New Jersey, that's the one that comes to mind and actually has a coastline. Otherwise, the coastal states are generally broken up into several different districts. There's a few oddities in there. New Hampshire, I guess, has a coastline. Very tiny one. But the defendant cannot be found within that district, meaning they are not subject to personal jurisdiction and cannot be served with process there. Third requirement, and the most important one, is that the defendant's property can be found within that district. That's fairly self-explanatory. And then the last requirement, which I've never seen anyone argue over, is that there are no maritime or statutory bars to the attachment. I have not yet figured out what a maritime law bar would be. Statutory bar would mean a statute of limitations. Just a bit of commentary there. I would interpret, my expectation would be that the meaning of maritime law bar, which no decision has addressed in many, many years, is that they're probably referring to the concept of latches, which is the maritime law equivalent of a statute of limitations, but not necessarily quite the same as a statute of limitations. Latches are a more flexible concept employed in maritime law, at least in the US, whereas I think English maritime law does have a statute of limitations, 6 years for a contract. So those are the four requirements for Rule B maritime attachment. Prima facie maritime claim, defendant can't be found in the district, property can be found in the district, and there's no bars to the attachment. If you satisfy all of those, it's quick, it's easy, it's relatively inexpensive, generally, to go and seize an asset. Magic is in finding the asset and one that's sufficient to actually get the other side's attention. Rule C, arrest. Arrest is based upon a claim against the asset itself. It is a mechanism to enforce a maritime lien and only a maritime lien, or statutory creations which are analogous to maritime liens, such as, and this is of interest for those dealing with vessel finance, such as the mortgage lien, which is created under the CHMLA, or Commercial Instruments and Maritime Liens Act, which is historically not a maritime lien, but under the statute becomes analogous to and treated the same as a maritime lien. So arrest is the mechanism to enforce a lien if it's a maritime lien and you hold one against a maritime asset. Types of assets out there that can be subjected to maritime liens. Obviously, vessels, for instances such as the provision of necessaries to those vessels. Cargo, when a charter party establishes a lien against cargo and it's subject to U.S. law. Further topic that we'll talk about more, and it's really quite interesting actually to delve into. Freights, and that's something I'm going to get into momentarily here. Freights owed to a vessel, technically, not owed to the owner, but owed to the vessel until they're received by the vessel's owner, are considered maritime property that is a part of the vessel until they are received by the vessel's owners or agents. That's where I wanted to talk a little bit, and I'll skip discussing state law remedies and its seizure remedies just to move things along a little bit here. It's freights where I wanted to talk a little bit about creativity. Going back to the 2009 decision in Jaldhi, or Shipping Corporation of India, the basic point of the Second Circuit was that wire transfers being processed by an intermediary bank could not be seized pursuant to Rule B, maritime attachment, because neither the originator of that wire transfer nor the beneficiary of that wire transfer had a property interest in the funds that were being processed at the intermediary bank. That was the gist of the holding in Jaldhi. What I have wondered about, and I believe is correct technically, is whether Rule C arrest could be used to seize funds being processed at an intermediary bank when those funds are for the payment of freight. Here's how I would see that working. There is ample historical precedent, at least under US law, that outstanding freights constitute a part of the vessel as much as its tackle and masts and other gear. Outstanding freights, up until the point at which those freights have been received either by the vessel's owner or by the agents of the vessel owner. An intermediary bank processing a wire transfer is not the agent of the originator of that transfer or the beneficiary of that transfer. There are at least two banks that stand between the originator, the beneficiary, and the intermediary. In the middle there, intermediary is not an agent. There's also no control to establish agency nor an agreement to have an agency. So the funds there are freight. Freight is part of a vessel. My view is that you should be able to arrest under Rule C those freights when they're at the intermediary bank. Practical question, I'm sure it's popping up in numerous heads right now, is, well, that's great in theory, but as a practical, pragmatic matter, how does the bank in the middle there know that these are freights? And how do you convince a court that there are going to be freights that can be identified as freights clearly? It's a good question, but what I've seen on wire transfers used for the payment of freight is that almost invariably the wire transfers are denominated as freight for voyage number whatever of MV Ed Floyd, or in some instances, hire payment number 15 under charter part, time charter, whatever, for the MV Ed Floyd. The wire transfers themselves reference freight and the vessel name. And that makes an awful lot of sense given that U.S. banking is highly regulated, and part of the regulatory environment includes compliance with the sanctions regime monitored by OFAC, Office of Foreign Asset Control, and OFAC occasionally has the habit of designating vessels as specially designated nationals, sanctioned persons. So vessel names and the identification of a freight payment make their way into wire transfer reports, SWIFT records, and get run through the SWIFT and, not the SWIFT, but the OFAC monitoring system used by banks. That practical problem shouldn't be there for most freight payments. So the freight payments, I believe, can be subjected to arrest under Rule C. There certainly are some fine lines to consider. There is a Second Circuit decision from the mid-1990s, International Nederlander Bank versus MV San Sebastian, in that the Second Circuit drew a distinction in connection with other issues between freights and subfreights. And it defined subfreights as being more akin to accounts payable, whereas freights themselves are actual funds that are traceable into other hands, and a claimant can follow freights because they are traceable. I'm not sure I agree, if I may, with the Second Circuit making that distinction, but I don't think I'll win that argument, at least today. But even with that consideration in play, whether there's a distinction between freights and subfreights, there would always be the open question of what are subfreights, because in my mind, and then I'll move on and take some questions there. In my mind, subfreights, the linguistics of it, the semantics, means freights that are below some other freights. So I do not think that the first voyage charter in a chain of chartering, the first voyage charter underneath a time charter, would constitute subfreights. It's freights. Underneath that first level voyage charter or a bill underneath it, there might well be true subfreights, but I don't think the first level voyage charter would constitute subfreights. In any event, my take overall, be creative on asset seizure. There are possibilities out there, and it requires a creative approach, but we've had good success in continuing to seize assets to secure claims. And I would encourage everyone to have an open mind about the opportunities out there for securing claims. You have good claims, don't let them go to waste. With that, any questions or comments? In an ideal world, which always start with that premise, I guess, in an ideal world, one would have some intelligence, perhaps from the inside, as to when freights are being paid. I would also suggest going on into the court under a sealing order. You can generally get a sealing order. There's other ways to move quickly and get an order without getting noticed, because our friends up at TradeWinds just love to publish information at inopportune times. Getting an order, if one doesn't need to push it to seize something, will generally take anywhere from 2 to 3 days, maybe a week. But you can get yourself, the attorney can get themselves in front of the so-called Part 1 judge or emergency judge, it varies by name, in the different districts around the country, and get an order right then and there. We recently obtained a same-day attachment order to seize a vessel in a different district, not New York, same-day turnaround. But that meant pushing to get in front of the judge and say, this is important, we need to have it happen. In terms of freight, I think that the time frame would be a little less pressing, because freight's going to get paid usually upon the issuance of bills, or the remaining 5% either at the time of or 30 days after the completion of discharge. Terms are going to vary, but one could look at vessel track or marine traffic or one of those, see where the ship is, how much time it's spent at port, and make a ballpark guesstimate as to when freight is going to become due, either the initial 90 or 95% or the remaining balance of 5%. It's an excellent question. It's 100% correct. I think that the decision in Jaldhi was certainly influenced by the burden that had been placed on the courts, as well as pressure that was coming from the bankers group represented at that time by Sullivan and Cromwell. They worked for 10 years to try to kill off that procedure. And then eventually the courts listened to them because they were overburdened. Judges, particularly those who were around during the 2000s and saw the rush of claims, and the newer judges don't have recollection of that. Likewise, if one were to try this initially, say in the Western District of New York, where I think it's HSBC has its processing facilities, or in the Eastern District of New York, where, at least last time I saw, the Citibank building is still there in Long Island City, you might get a little bit of a different environment. I would still stick in the New York, New Jersey area for the initial shot, because with the exception of Georgia, that's where the vast majority of banks have their headquarters and where wire transfers get processed. It would be a bit luck of the draw, hoping that one does not draw a district judge from the 2000s period who had an animosity towards Rule B. But even if that were the case, the legal argument for doing this is quite strong. Most federal judges are not going to reject a sound legal argument just because they have a policy or a personal preference against that legal argument and what the outcome might be. Additionally, I think that I would be inclined maybe not in initial papers, but I'd have something written up in advance to put in as well, to make an argument that this particular procedure would not create, this use of the procedure would not create the same sort of mass rush to the courthouse that Rule B had created, because Rule B involved parties going after any and all payments, processing through any and all banks. So when we would go to seize wire transfers, it would not just be a targeted 1 or 2 banks, but it would be a dozen, maybe 24 banks. You throw on some others as well, other financial institutions. Here, a judge would want to know, what bank do you think, or what 2 banks do you think these funds are going to go through? Having a guess about that, or informed intelligence, would mean knowing what overseas bank the defendant typically uses, and then going to that bank's website and looking up who their correspondent banks in New York are. That's generally publicly available information. And that narrows it down to 2 or 3 banks. The associated problems and logistical confusion that annoyed the courts previously starts to go away. So demurrage on there? Well, demurrage would be an interesting argument, because that would trigger the question. Luke and I love going back and forth between US law and English law, and slight distinctions out there. If demurrage is in there and the charter party is governed by US law, my argument would be, wonderful, so be it, it's freight. Reason for that is that under US law, demurrage is generally considered to be extended freight, whereas under English law, demurrage is generally considered to be liquidated damages, and thereby not freight. My take, if a bank called me and said, yeah, you managed to arrest $1 million, 700,000 of that amount is for freight, another 200,000 is for demurrage, and 100,000 is for port disbursements, I think I would just say, wonderful, thank you, Mr. Banker, and let the other side show up and argue that the money should be released. If you're talking about $10 million in excess funds, well, then maybe you give it some thought. But I would take a very pragmatic and flexible approach to that.